Well, hello everyone. Welcome to our third Tuesday webinar. Today we'll be talking about terminating an employee who just took FMLA and other tough employee discipline issues. I'm Britt Waterman. I'm one of the attorneys here at myHRcounsel, and I'm presenting today. Today on our agenda, we're going to talk about discipline, termination, and get into some case studies, some actual cases regarding discipline and termination. Housekeeping, after we are recording the presentation, after the presentation, we will send out an email to all the attendees with a link to the recording, the HRCI credit code, Q&A from any questions that we get during the presentation. And if you have any questions during the presentation, please feel free to type those in, and I'll get to those, try to get to those as they come in. We'll also send out a brief survey. It really helps if you complete this for us. It lets us know how we're doing and gives us ideas of what topics we can present on in the future. That's how we came up with the topic today, was through suggestions that we received after previous webinars. You'll also receive our employee counseling form, and this form can be used for employee coaching, counseling, or discipline, and you should receive these items within the next few business days. So we've got a lot of material to cover today. Like I said, I'll be looking at some of the questions as they come in. I'll answer as we have time. Anything that's not answered today will be included in the Q&A we send out. Just to let you know, this is general information for educational purposes only. We can't provide specific legal advice in this format. So if you've got a question about a specific situation for an employee that you have going on, I'll be unable to answer that question in this forum. If you're one of our clients, we can certainly follow up in depth after the presentation. Feel free to open a new ticket in our Ask system with the specific question that you have. If you're not one of our clients and you need some assistance with a specific situation, please sign up for myHRcounsel, and we will get you set up with our Ask ticketing system. You can submit the specific question to us, and one of our attorneys will be happy to answer that for you. So today is just general information for educational purposes. It's not considered legal advice. So let's get started. Let's talk about the importance of discipline. So discipline is very important for a number of reasons. Managing employee and employer expectations. It affects the retention of employees. Discipline can provide support for future termination if that's necessary. It can definitely provide you with documentation that's essential if an employee were to former employee were to go on and file a claim against you. And it prevents employees from being caught off guard if a termination occurs. Discipline puts employees on notice that their performance and conduct is being monitored, and it can encourage improvement and discourage future undesirable conduct. A discipline meeting can also serve as a brainstorming session of what that employee needs to be successful. As I'm sure you know, it's always cheaper and more efficient to try and turn around an employee who may be struggling than it is having to go through the whole hiring process and training process with a new employee. Also, if an employee knows what the expectations are and they need some type of accommodation for a disability, for example, the discipline meeting gives the employee a chance to say, you know, hey, I'm not performing because I need this type of accommodation, this type of help. It gives them a chance to request that, and it keeps them from later saying, you know, I needed accommodation and I wasn't given one, and I was, you know, terminated or given further discipline. If termination occurs in the future after protected activity occurs, or if the employee is in a protected class, and we'll get into in a little bit about what protected activity means. But if a termination occurs in the future, this discipline can show you that the performance or the conduct issue occurred before the protected activity. So if you're terminating someone who took FMLA and they've been disciplined throughout their employment, this having a record of discipline can show that the conduct occurred before they took FMLA and that the employee knew what the consequences were if it happened again. Another thing is that an employee who's caught by surprise by a termination is more likely to turn around and file a claim against you, as opposed to an employee who knows that this is coming, who knows that there has been an issue that's been ongoing and is not surprised by the termination. So discipline done right. There's a right way and a wrong way to discipline an employee, and the right way is to make sure that you're clear about what the issue is and what you're looking for. And so any type of coaching or discipline will provide the employee with the answers to the following questions. What is the undesirable conduct or performance issue? What is the expectation going forward? What is the metric by which the improvement will be measured? When will the performance or conduct be reassessed? And what is the consequence if performance or conduct is not improved? An example of this would be, so you're going to discipline for attendance. You've got someone who's habitually tardy. So what is the undesirable conduct? Well, the undesirable conduct is tardiness. What is the expectation? The expectation is arrive at work on time every day. What is the metric by which improvement will be measured? The metric is the number of times that the employee is tardy and how late they are. When will the performance or conduct be reassessed? We're going to look back in a month. So 1 month, we're going to look back, and if there's another, what is the consequence if it's not improved? If there's another incident of tardiness in that month, when we look back, say we'll move to a final written warning, for example. An example with a performance issue, it could be the undesirable performance is low sales. The expectation is X number of sales per month. Sales numbers will be reassessed in 2 months. If sales are below X number of sales, then termination. So you're laying it out for the employee. This is what we're seeing. This is what we want to see. This is how we're going to measure this. This is how, when we're going to talk to this again about this again, or when we expect to see the change. And this is what's going to happen. And so this, again, this keeps an employee from being caught off guard and reduces the chance that the employee may file a claim against you if termination does occur. Documenting discipline. I know that those of you who are our clients and have dealt with discipline or termination issues before have heard us say document, 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 and document some more. There's no discipline that's too big or too small to document in writing. Whether it's a verbal warning, even if it's a verbal warning, the individual issuing the warning should still write up what the issue was and what was said in the meeting. You should, if there's a disciplinary meeting, whether it's a verbal warning or a written warning, it's important to have a private meeting away from distractions. You could consider having 2 employer representatives in a disciplinary meeting. If you have a supervisor and someone from HR, for example, that allows one person to deliver the discipline and one person to take notes in the meeting. Allowing the employee to add a written statement and acknowledge receipt is always helpful. Sometimes an employee, doesn't want to sign the disciplinary warning because they think that that means they agree with it. Instead, saying, we'd like you to add any comments you have about the discipline, adding that written statement. Again, that provides documentation that the warning was received by the employee, and it can put you on notice if the employee needs leave, if they need accommodation, if there's been a harassment issue going on that you need to investigate. For example, you're issuing an attendance warning, you've got an employee who's just been calling out for no reason. You say, here's the disciplinary warning. You can add a written statement. They add a written statement saying that they've been having migraine headaches. That could put you on notice of that the employee may need intermittent FMLA or need an accommodation under the ADA. So that's having that written statement can actually be very helpful to you and helpful to the employee. The employee feels as though they're being heard as well. With documenting discipline, the time to start documenting discipline is when the problem starts to occur. If you don't have any documentation and you're giving verbal warnings or verbal coachings and you're not documenting anything, and then you're ready to terminate and all of a sudden you start piling on the warnings and padding the file at the point of termination, that's going to backfire on you. That's if an employee files a claim against you and says, well, they made up this pretextual reason for terminating me, and you say, well, no, we have all this documentation, and they say, well, this documentation all came, started a week before they were terminated, that's going to backfire. That's going to look like you were trying to fabricate a reason for the termination. So the time to start disciplining is as soon as the problem or the performance or the conduct issue starts to occur. Progressive disciplinary policies. We see these a lot. A lot of employers like to have a progressive disciplinary policy. It can build evidence of a valid business reason for termination if you've got someone and they're going through the steps and their conduct or their performance is not improving. Having the progressive disciplinary steps, you're giving the employees a chance to reform and succeed, so you're boosting your retention. If you have a progressive discipline policy, it should provide that you may move to any step in the process at any time based on the nature of the infraction. You don't want to have it so strict saying everybody will get a verbal warning and then everybody will get a written warning and then everybody will get a performance improvement program. If you've got, somebody who steals, $500 from the till, you're not going to want to give a verbal warning for that and, let them continue handling cash. If an employee claims that they were retaliated against, it helps your case to have the file full of warnings for the conduct that led to the termination. So that again, with the progressive disciplinary policy, you've got periodical warnings for the conduct that's occurring. As far as a policy providing that you may move to any step in the process, some good language to have in your handbook would be every employee at company is employed at will. This means we are free to terminate the employment relationship at any time for any reason. Depending upon the circumstances, disciplinary action may take any or all of the following forms, even on a first infraction, and then lay out your steps. Verbal warning, coaching, counseling, written warning, final written warning, last chance warning, performance improvement plan, whatever the steps are in your policy. And helping with that policy language is definitely something that we can do for our clients when helping you revise your handbook. Termination, going back to, again, documenting. You want to make sure you gather warnings, investigation notes, witness statements. If you've got a harassment issue or a discrimination issue, you want to keep a separate investigation file. So if you're terminating someone for harassment, and you want to make sure you keep those witness statements and interview with the victim in a separate investigation file. You don't want to stick that in the personnel file because the employee can request a copy of their personnel file, and you want to protect the victim in that case. So if that's just as far as documentation goes, if it's a performance issue, definitely keep that in the personnel file. If it's something like harassment or discrimination and you're taking witness accounts from victims and that something of that nature, keep a separate investigation file. Assess your liability risk. Has this person engaged in protected activity? So have they taken FMLA? Have they requested an accommodation? Have they filed a claim of discrimination? Are they a member of a protected class? This is a great time to consult with counsel, to reach out to one of the attorneys here at myHRcounsel and say, what is our risk? What are the risks that we're looking at if we terminate this individual at this time? And then consider a separation agreement. Separation agreement, the employee waives their right to sue you in exchange for a payment, as commonly referred to as severance pay. This can be helpful if the employee is a member of a protected class or has recently engaged in protected activity like taking FMLA or requesting an accommodation or maybe union organizing activity like that. Some employers fear that, well, if we present them with a separation agreement, they're going to get the idea that we've done something wrong and they're going to go, run to a plaintiff's lawyer. That fear is usually unfounded. Employees who have the idea to run to a plaintiff's lawyer and file a suit usually have that idea in their head already. And the one thing about a separation agreement that does not protect you from, employees can still make a report to OSHA or to the EEOC, but they cannot recover financially from you. So the separation agreement protects you financially. So protected activity, I've been referring to that through the previous slides. Protected activity can include making a complaint, so either internal or external, of harassment or discrimination, taking protected leave, that would be FMLA or ADA leave, making a complaint to a government or regulatory agency, commonly called whistleblowing, or organizing for mutual aid or concerted activity. That could be organizing to protest unfair working conditions, union organizing, that type of activity. So that's all protected by law. You can't take an adverse employment action against someone because they engaged in this protected activity. Retaliation claims. So retaliation requires three elements. One, that they engaged in protected activity. Two, that you took some adverse employment action, so firing, demotion, suspension. And three, some connection between one and two. So disciplining or terminating someone in close proximity to that protected activity may lead to a claim of retaliation. And one thing that's really important to note about retaliation claims is that a retaliation claim may succeed even if there is no underlying harassment, discrimination, illegal or unethical activity, or unfair labor practices are found. So an employee could say, make a complaint and say, well, I was discriminated against for my race. And you could terminate that employee, and a court could find, you know what, there was no racial discrimination. That didn't happen. But they could still succeed on the claim of retaliation if they can prove that they were terminated for making the complaint. So even if there is no underlying discrimination or illegal activity, if you retaliate by taking an adverse action against them for making the complaint, they can still succeed on that claim. So it's not enough just to investigate and say, well, we didn't find anything, so it's fine to terminate this employee. You have to be very careful doing that. You cannot terminate someone in retaliation for that protected activity, making a complaint or activity of that nature. And I want to answer a question here. So we got a question. What do you do when the employee tells you about the migraines but fails to follow up by completing the accommodation paperwork or calling into HR to start the intermittent leave process? If you give them the FMLA paperwork and you say you have to return this within 15 days to have your intermittent leave qualified as FMLA leave, and they do not return the paperwork, and you give them a letter saying, we haven't received your paperwork, you have 7 days, we're going to give you 7 more days to turn in this paperwork, and they don't turn it in, you don't designate the leave as FMLA. You need that certification of healthcare provider. So if they, If you give them the 15 days, give them a warning, give them 7 more days, they don't turn that FMLA paperwork in, you do not designate the FMLA, and then that's not FMLA interference. It could still be retaliation if you terminate them for requesting FMLA, but it's not interference, and you can start the disciplinary process for attendance if they're not following up on the FMLA paperwork. The same with the ADA accommodation process. If you give them the interactive process questionnaire to take to the healthcare provider to give you more information about the disability, and they fail to return that paperwork, and like I said, I would always advise giving them a second chance, waiting the 15 days, giving them another letter saying, we really need this, giving them another 7 to 10 days. At that point, if they haven't returned anything, they've failed to engage in the interactive process, and they're not protected under the ADA there, so you do not have to accommodate if they're failing to return those forms. They're refusing to participate in the interactive process. So Shinn and Ellis versus Fedex Freight Incorporated. So this is a case where Shinn and Ellis were coworkers at FedEx. On May 7th, a coworker of Shinn and Ellis used homophobic slurs to refer to Shinn and Ellis. It escalated, and Shinn and the coworker started shouting obscenities at each other, and Shinn asked the coworker to take it outside. Another coworker was a bystander, reported it, and FedEx interviewed both the use of homophobic slurs and the threat of violence, asking them to take it outside. And FedEx terminated Shinn on May 21st for making a threat of violence by saying, let's take this outside. They had a zero tolerance policy for workplace violence. Their policy provided that workplace violence was cause for termination. And so Shinn threatened this coworker, and then he participated in the investigation of harassment. He said this person used homophobic slurs against me, and participated in the investigation. So he was terminated. The person using the slurs was suspended for 3 days. And Ellis, who was also on the receiving end of the homophobic slurs, used intermittent FMLA for chronic back pain and also to care for his sick mother. So the location where Shinn and Ellis worked had 42 employees using FMLA, either intermittently or continuously at the time. Ellis used the intermittent FMLA for his back pain and care for his mother for 2 years. And, he kept requalifying on a rolling basis. And during these 2 years, he received pay raises and benefits. He was never denied the time off. And Ellis made a Facebook post saying a coworker was going to have an accident on the dock. FedEx investigated that and found that that was a threat. And so Ellis was also terminated for workplace violence for threatening this coworker. So both Shinn and Ellis brought retaliation claims under the New Jersey law against discrimination, and Ellis also claimed FMLA retaliation. So Shinn claimed that the proximity between May 7th, when the incident occurred and the investigation started, and May 21st shows that he was retaliated against. But there's nothing else to show retaliation. In fact, of the 11 employees interviews, 9 of the employees are still employed by FedEx. So, it shows that it's unlikely that FedEx was retaliating when they only picked the one employee to terminate as a result. And also they, had evidence of a valid non-retaliatory reason for termination, which was the making the threat that 11 employees or 10 employees overheard Shinn making. Ellis was terminated 2 months after the investigation occurred, and so the court found that that was too long to suggest a causal relationship between Ellis's participation in the investigation, and that was too long to show that Ellis was retaliated against for participating in the investigation. And there was no evidence that would make, the court found there was no evidence that would make a jury doubt Fedex's stated reason for termination, which is violating that workplace violence policy. Ellis's FMLA retaliation claim also does not succeed. Fedex had 42 other employees using FMLA, and Ellis was just one of these employees. I mean, they're obviously not trying to pick off people who are using FMLA if they've got 42 employees using it. And also, Ellis had used FMLA for 2 years without incident. Rozumalski versus W.F. Baird and Associates. Rozumalski was sexually harassed by her supervisor. Baird, the company, investigated. They fired the supervisor. They promoted Rozumalski to the supervisor's position. They gave her a positive review and a bonus larger than her target bonus at the end of the year. 2013, she's promoted again, and she's given another bonus. December 2013, she's given a generally positive review that identified 4 areas needing improvement. She was given a bonus, but she was given this letter identifying 4 areas saying you need to improve in these areas. She refused to sign the review that identified the 4 areas needing improvement, and her work did not improve in the first quarter of 2014. So she didn't sign the review, and she did not. Her conduct did not improve. In February of 2014, she was given another letter about these performance concerns, and on March 20th and May 5th, she responded to Human Resources by letter criticizing the supervisor who gave her the review with the needs improvement items on it, saying that she believed that the supervisor who reviewed her was friends with the harasser who had been terminated, and suggested that the supervisor was retaliating against her for getting this harasser fired 2 years ago, and he was retaliating by negatively criticizing her performance. In May of 2013, then after sending this letter, she's given a formal performance improvement plan, and she sends in another letter saying, this performance improvement plan is my supervisor retaliating against me for getting his friend fired. May of 2014. She's given a performance improvement plan in response. This is my supervisor retaliating against me for getting his friend fired 2 years ago. And then after the performance improvement plan, part of the performance improvement plan is requiring Rozumalski to be in the office every day from 8 to 5. One day in May, she leaves the office for an hour and a half midday to go get her nails done, and she doesn't inform anyone. She is terminated for violating the performance improvement plan, and she sues for retaliation. The court found that there was protected activity, which is complaining against harassment, complaining about harassment and retaliation, the complaining about harassment that occurred back in 2012, and complaining about retaliation in March and May of 2014 when she said the supervisor was retaliating against her for getting his old friend fired. There's adverse employment action that the court found that the performance improvement plan significantly diminished her responsibilities, but the court found no link between the protected activity and termination. And like I said earlier, those are the three things you need. You need the protected activity, you need the adverse employment action, and you need the nexus between the two. So the court found the first two, but did not find the third. The court said, she's already received 2 letters criticizing her performance or showing needs improvement on her performance by the time she sent that March 20th letter complaining about retaliation. And she was on the performance improvement plan for 6 weeks between the time she sent the May 5th letter and the nail appointment incident. And so the needs improvement conversations happened before she complained of retaliation, and the termination occurred 6 weeks after she complained of retaliation. So the court said, the timing doesn't add up. Her complaint of retaliation, the complaint of the harassment occurred back in 2012. So the complaint of harassment was statutorily protected activity, but that happened 2 years ago, and she was promoted twice and received bonuses since that happened. So that was, the court considered that was too remote in time to her termination for there to be a connection there. And then the performance, the supervisor finding performance issues occurred before she ever complained about retaliation. Castro Ramirez versus Dependable Highway Express. This is one that did not go well for the employer. Castro Ramirez was hired in December of 2009. He told the employer when he was hired that he needs to be home at night to administer dialysis to his son. His son needed to start dialysis between 7 p.m. and midnight, and the dialysis needed to last for 10 to 12 hours. He communicated this with his supervisor. They arranged his schedule around this. On March 2013, his supervisor changed, and the former supervisor was promoted, and the new supervisor, like you said, 3.5 years, March 2013, he got the new supervisor. The new supervisor didn't want to work around Castro Ramirez's schedule. He didn't want to work around the hours Castro Ramirez needed to be with his son. And even to the point where a morning customer specifically requested Castro Ramirez, and the new supervisor told Castro Ramirez that this specific customer didn't like his work, and that's why he was being given later shifts. And the customer called Castro Ramirez directly and asked why he wasn't doing deliveries. So this is the new supervisor is saying, we're not going to give you just morning deliveries. We're going to, we're going to schedule you as we schedule you, and even though a morning customer was specifically requesting him. So on April 23rd of 2013, Castro Ramirez is assigned a shift by this new supervisor beginning at noon to do multiple pickups and deliveries, and this would not allow Castro Ramirez to get home by 8 o'clock to give dialysis to his son. And the manager tells Castro Ramirez, previous supervisor doesn't work here anymore. I'm your supervisor now, and if you don't do it, you're fired. And on the same day, the manager scheduled at least 8 other drivers to start before noon, including one to deliver to this morning delivery that had requested Castro Ramirez. So Castro Ramirez sued under the Fair Employment and Housing Act in California. And this is California law. This is not federal law, so this is only going to apply to California employers. But under the Federal Employment and Housing law, the association with a physically disabled person is itself a disability. So the court found that, so the employer moved to get the case dismissed, and the court said no, a jury could reasonably infer that Castro Ramirez was fired because of his association with his disabled son. He was scheduled later than ever before, despite 8 earlier shifts being available and an early customer requesting him specifically. So they found that Castro Ramirez was retaliated against for requesting a schedule accommodation to be with his disabled son. And so this, like I said, this was under California law. And in this case, Dependable Highway Express paid out $1.1 million to Castro Ramirez. They found that he was retaliated against for requesting accommodation for his association with a physically disabled person. And so what can we learn from this? One thing that we can learn from this case is train your managers. Train managers to, if they ever hear anything about an ongoing sickness, a sick child, a sick parent or family member, spouse, needing help, needing time off, anything medical or related to the individual or the family, they need to bring HR in. The previous supervisor, was accommodating Castro Ramirez, but didn't bring HR in to the point where when he got the new supervisor, Castro Ramirez didn't know what to do, and the new supervisor was not accommodating him. So definitely bring your managers, have your managers, train your managers to bring you into the loop when there's any possibility that an employee may need an accommodation or FMLA. And if, discipline managers, if they're not giving you the heads up, if they're not sharing that information, it's something that you should take very seriously. In this case, it ended up costing $1.1 million in a retaliation claim. Crawford versus Chipotle Mexican Grill. This is also one that did not turn out well for the employer. Alicia Crawford was an African-American employee. In early 2014, she heard reports that some African-American employees had their timesheets altered, which resulted in a reduction of hours that they were paid. Crawford confronted the manager, J.C. Torres, who admitted that, yes, he had altered timesheets to reflect favorably on Chipotle's performance report to show that he was keeping work hours down. So in March 2014, an African-American employee showed Ms. Crawford his paychecks, showing that he did not receive the back pay from the timesheet altering that he was promised. And Crawford confronted Torres and said, "You're discriminating against the African-American employee. You need to stop harassing him and you need to pay him his back pay." Torres responded that Crawford was only helping the employee because she is African-American. And less than 2 weeks later, Torres fired Crawford and told her it was due to coworkers making complaints about her. And Crawford asked why she hadn't heard any complaints before, and Torres said it didn't really become a problem until Friday. So this is less than 2 weeks after she makes the complaint of discrimination to the manager. So when it went to court and the employer moved for summary judgment, moved to get the case thrown out, and the court said Crawford lost on the discrimination claim. They said the Torres making the response that Crawford was only helping the employee because she's African American. The court said, that's not enough for discrimination. But they said she met the elements to go forward on the retaliation claim. Her protected activity was making a complaint about discrimination. She complained that these African American employees were not getting their back pay. So that was an internal complaint that she made to her supervisor, and that was found to be protected activity. There was an adverse employment action. She was terminated, and there was a connection between the two. She was terminated after making the complaint. Chipotle argued that her complaint of discrimination was too vague to be considered protected activity, and the court disagreed. The court said the employee only needed to establish that he or she challenged an employment practice that he or she reasonably believed was unlawful. So complaining to a manager saying, an employee saying to a manager, "I don't like the way African American employees are treated around here," that's protected activity. That's not too vague. That's that's a complaint of discrimination. That's protected activity. So again, train your managers. managers need to know that, even something as minor as that needs to be brought to HR, because that could be considered protected activity, or, any, an employee saying, well, a female employee saying, male employee makes me uncomfortable. That could be protected activity. So train managers to loop HR in anytime there's any sort of complaint of discrimination or harassment, or might be discrimination or harassment, because that could be considered protected activity. And then if that employee is disciplined or terminated as a, and there's a connection between that and the protected activity, that employee can succeed on a retaliation claim. So the takeaway is retaliation claims can succeed even when there is found to be no underlying discrimination, and a complaint of discrimination, harassment, whistleblowing, it does not need to be a formal complaint to be protected activity. Nieves versus Envoy Air. In April 2015, Envoy selected Nieves for a random audit of his travel privileges. He was a gate agent for an airline. He had travel privileges, which was immediate family members could travel at free or a discount rate. And the company periodically audited the employees' travel logs to make sure that they were only extending these travel privileges to individuals who qualified as immediate family members. So they started the audit in spring 2015. They mailed Nieves a letter in April and one in June 2015 telling him to send proof of eligibility for everyone on his travel log to show proof that they were immediate family members. He faxed documentation only for his wife and his stepdaughter, even though they had 7 children together. And he also had the son of his wife's friend, his wife's half-brother, and his mother's boyfriend on his travel log, even though they were not eligible. So this goes on until September 2015, when the head of HR decides to make the audit a priority, but the audit process is still moving slow. January 26th of 2016, HR tries to schedule an interview to talk about his travel log, and the manager says, well, he's been out since January 4th. He's been hospitalized for kidney failure. The HR tells the manager how to get Nieves on FMLA, but FMLA paperwork had actually been completed on January 12th, so the manager gave him FMLA paperwork, but did not turn that in to HR. Nieves returns to work on February 19th. HR and his manager conduct a telephone interview on March 9th. They give him 9 days to provide documentation of eligibility. He sends some letters saying, explaining that the people who were not immediate family members are like family members to him, but this is not legal documentation to support their eligibility. The employer's policy is termination for ineligible travelers using the employee's travel privileges. That's a blanket policy. If you let ineligible travelers use your travel privileges, you're terminated. So he's terminated. He engaged in protected activity. He took FMLA in January and February, and he's terminated on March 30th. So there's the protected activity, there's the adverse employment action, and is there a connection? Well, in this case, they found that there's not a connection. They found that there is the valid business reason for termination. They found that a jury could reasonably find that the reason for the termination was the misuse of travel privileges. He had some other claims. He claimed that a supervisor said that he should retire in response to his wife saying how ill he was and could barely work. They found that there was no causal connection there between the supervisor making that comment and him being terminated. Human Resources wrote frequent FML in her notes, and he claimed that that was retaliation for taking, he showed that the HR employee was retaliating, but she explained that that was, she was trying to figure out when to schedule an interview, not criticizing his use of FMLA. So in that case, they terminated him in accordance with a policy that was applied consistently. So that's, consistency is important, and that's why having a good disciplinary policy and following your disciplinary policies, keeping that consistent, is always helpful. Friday versus Magnifique Perfumes and Cosmetics. This is woman Michelle Friday. She began working as an assistant manager of a retail store in 2011. She was promoted in 2013. And her condition did not prevent her from, she had an auto accident that limited the use of her hands and caused her hands to atrophy, but the condition did not prevent her from doing her job. Each store does a full inventory count each January and tracks the shrink rate. And shrink rate is the loss of product that's lost or stolen from each store. Friday's store had a history of a poor shrink rate. The inventory is done in January. The numbers came back in March, and the previous shrink rates had been higher in previous years, and nothing had happened to Friday as a result of that. But in January of 2016, during the inventory count, Friday's supervisor told her that her hands were disgusting. And Friday, so after this happens, Friday sends multiple emails to the district manager explaining, what happened and complaining about what happened and explaining the shrink rate. And he never responded to her. The court found that she was terminated, and the court found that this could be pretext. It did go to a jury. She sued for disability and gender discrimination. And if there would have been good HR oversight and a formal disciplinary process in place, this could have been avoided. I don't know what the payout was on this case. I don't know what the consequence was on this case for the employer, but it did go to a jury. And this is just another example of an employee making a complaint. So she made a complaint about the supervisor's comment, and then she was terminated for something that had happened before repeatedly that she had never been disciplined or warned for. So this is another case where the employer maybe could have succeeded on getting the case thrown out if she had been repeatedly disciplined for shrink rate up until this point. Then their discharge of her for their, giving the reason as the excessive shrink rate as the reason for termination, that's going to be supported if they can show that that's something that she had been disciplined for, rather than coming up with it last minute and saying, oh, well, she made a complaint, but that's not the reason. So I'm just looking to see if we have any questions here. We have a little bit of extra time. so if there aren't any further questions, I think we can end on that note. If you have, like I said, any further questions, please feel free to reach out to us. You can, if you are our current clients, you can feel free to submit a ticket in our Ask portal, or you can email at info@myHRcounsel.com. If you are not one of our clients, please sign up. We can help with all of the related issues we spoke about today: FMLA, ADA, discipline, discharge, retaliation, discrimination. These are all things that we can walk you through if these come up in your day-to-day dealings with your workforce, and helping to train managers as well. Our contact info is here, info@myHRcounsel.com, or you can go to our website at myHRcounselcompliance.com. And again, we will be sending out that employee counseling form and the HRCI credit code within the next few business days. So thank you all for being here, and I hope you all enjoy the rest of your day.